does not matter if the goods have been, or the copyrighted goods have been acquired lawfully. So the interpretation was of the word, whether it is lawfully acquired. So in that case, one student, XIII from Thailand, he was studying in a university in US, and he imported the books which were sold in Thailand at a lower price. So the Asia edition was at a lower price. So his friends and relatives, they purchased the goods lawfully in Thailand and online transferred the books to him in US, and there he started selling the books. And there the question was whether it is an infringement or not, but the Supreme Court upheld there was no infringement. So as far as the copyright is concerned, United States follow, as per the Supreme Court judgment, the principles of international exhaustion. Now, a lot of controversy is arising between this international exhaustion issue. Even in the United States, Federal Circuit Court of Appeal, they have been giving judgment against international exhaustion, and in two judgments which are very important, and these judgments are Melanie-Kraft versus Medipart, and another judgment of Judge Photo. In these two cases, the Federal Circuit has given judgment against it, but in case of Qantas Computer versus LGE, and in the latest judgment where the certiorari has been granted on December 16, 2016 by the Supreme Court in the Lexmark impression versus impression. So that judgment, if it comes, and the people are very, very uncertain what the Supreme Court of United States will held in that Lexmark judgment. So if the Supreme Court, similar to XIII, decides also in favor of the person who has like impression, so in that case, though the statute will have one stand, but the interpretation of the law may go in favor of the defendant, and the patentee may not be able to take up the case for infringement. So the legal statute position is one, but the judges are giving their opinion differently. So what I am trying to say is that the people's demand, the demand of the society, goes largely in favor of international exhaustion. So therefore, the time has come for harmonization of this law on international exhaustion, and the WTO needs to look at the real demand of the society. And in the forthcoming WTO Ministerial Conference, I think after the Supreme Court judgment, which may come sometime in June or July 2017, so after the Lexmark judgment, which should be a very, very striking time for the world community to decide on this issue. So what we could not do during the Uruguay round, probably we can do in the next Ministerial Conference. Thank you all very much.